Добрый день.
Dear colleagues, allow me to open the meeting of the Dissertation Board dedicated to the dissertation by Manzura Khamidova in the subject 120010, International Law, European Law. The topic of the dissertation is legal consequences, legal implications of Tajikistan's accession to the ICC statute. Please switch off your mobile phones. At present, the defense is broadcast live on the St. Petersburg University website. Simultaneous interpretation into English is being provided. May I inform you that according to federal law issued on the 23rd of May 2016, St. Petersburg State University and Moscow State University have been granted an exceptional title to independently award scientific degrees. Scientific degrees are awarded only in the subjects and areas of science contained in the Scientific Subjects Register. This Dissertation Council is deemed legitimate if attended by at least 2/3 of the improved composition of the Dissertation Council. In our case, at least 4 persons, 4 members, because this Dissertation Council comprises 6 members. 4 members of the Dissertation Council are present at this meeting. 2 members have joined us online. Thus, the quorum is present. The Dissertation Council is present at the meeting in full. Please be advised that this meeting must be completed within a 2-hour framework. We will be limited for time. So our defendant will be granted a 15-minute time limit for his statement. Every member of the Dissertation Council will be entitled to make a 10-minute presentation. Please adhere to the time limits. Members of the audience will be eligible for 5 minutes of statement. The scientific advisor will make a 5-minute contribution. The Dissertation Council comprises 6 members. I am the chairperson, Ludmila Galinskaya, professor of the Department of International Law, St. Petersburg State University. Seated next to me is Professor Valentina Marunchik, Doctor of Law, Associate Professor of the Department of International Law of St. Petersburg State University. Nikolai Stoyko, Doctor of Law, Associate Professor, Docent of the Department of Criminal Proceedings and Criminology of St. Petersburg State University. And Evgeny Lakov, Doctor of Law, Docent of the Department of Constitutional and International Law of the Russian Customs Academy. Joining us online are Rybul Valeev, Doctor of Law, Professor of the Department of International and European Law, Kazan Federal University, and Nizami Safarov, Doctor of Law, Head of the Department of Administrative and Military Legislation of the Parliament of the Republic of Azerbaijan. According to our agenda, let me give you an overview of the documents submitted by the defendant. I won't go into too much detail. Just let me mention that the candidate, the defendant, has submitted also due certificates confirming the fact that the defendant took a PhD course at our university. There is a review by the scientific advisor, by the supervisor, a list of publications including 6 articles published in the sources comprised in the list approved by the Ministry of Education, a list of qualification examinations passed, a copy of Diploma Magna Cum Laude, and her dissertation in Russian and English. All the documents are compliant to Clause 12, Section 3 of the Procedure for the Award of Scientific Degrees at St. Petersburg State University. Are there any questions regarding the documents? We have a comment from Professor Lakov, who says that he's mentioned in the documents as a docent, associate professor, when he is a full professor, and he has been so for 25 years. Please accept my apologies. Yes, this is something that we noticed too. Grave offense, grave offense. Manzura, you're welcome. You have the floor now. Remember about your 5-minute time limit.
Distinguished members of the Dissertation Board, distinguished members of the audience, may I present my dissertation devoted to legal implications of Tajikistan's accession to the International Criminal Court Statute. The relevance of my research is that Tajikistan is one of the first CIS countries that is a non-ratifying signatory to this statute. Therefore, whereas for other CIS countries, ratification of the ICC statute is being discussed now, for Tajikistan, this issue is ultimately relevant because Tajikistan has to comply with the statute practically and theoretically. So far, a number of issues have been unresolved related to the ICC activities, including most efficient forms of the statute implementation. discrimination between the jurisdiction of the court and its state parties, as well as identification of best practices in terms of cooperation between the state parties and the third parties on the surrender of citizens to the ICC. These were the issues that were in the focus for us. The International Criminal Court has the power to prosecute individuals only. However, the analysis of the statute provisions as well as the ICC practices allows us to showcase that by prosecuting top-rank officials for international crimes, the ICC thus casts a negative shade on both official authorities as well as the states that were idle to counter such crimes. Another problem is potential bias, which can be an impediment or even an obstacle to due prosecution. My conclusions are as follows. One of the findings shows that the statute norms that comply with the principle of complementarity on the one hand and the constitutional norms of Tajikistan on the other do not contradict. The ICC is just an alternative judicial body to investigate crimes and to persecute criminals, citizens of state parties. Therefore, these are the state parties who are responsible for prosecution, and therefore the national Tajikistan's jurisdiction has a priority. Most part of my research is devoted to the analysis of Tajikistan's law in terms of its compliance with the ICC statute provisions. I found out that the principles of the Part 3 of the statute are totally enshrined in the Tajikistan's legislation, apart from 3 issues which have no significance. Tajikistan's law establishes the legal regimes when the country can independently persecute crimes. While comparing the ICC statute provisions and Tajikistan's law, I managed to identify that Tajikistan's criminal law is in compliance with the ICC statute norms in terms of how it defines a number of crimes. However, for 2 types of crimes, there are discordances. Many issues of cooperation between Tajikistan and the ICC have not been regulated properly. For example, cooperation between national judicial bodies and the ICC, as well as legal assistance. To this end, I suggest to adopt a law on international cooperation with the ICC. Tajikistan has also failed to sign the Treaty on Privileges and Immunities of the ICC as of 2002. However, this could be a practical tool for Tajikistan. This treaty broadens the list of entities that have privileges within the territory of state parties. A relevant agreement between Tajikistan and the US on ICC surrender of citizens has been signed in 2002. This agreement provides that citizens who are located within a specific country cannot be surrendered to the ICC unless there is an agreement obtained from the ICC. This situation may require incompatible actions. It looks like Tajikistan has to provide an offer to the US to amend this agreement, or otherwise to terminate this agreement. Overall, I should say that Tajikistan's accession to the ICC statute reinforced its legal system and reinforced tools for implementation of human rights. Thank you very much for your attention. Any questions? I have one question. What's your take on the critical analysis of the ICC by the representatives of African countries on the one hand, including the decree of Russia's president that Russia will not be a state party to the ICC statute? Thank you very much for the question. Well, indeed, there is such criticism, and the ICC is criticized a lot indeed. To this end, in St. Petersburg University, we had a relevant conference. And I asked this particular question to the former chair of the ICC. Yes, indeed, lately, in research papers, we see a lot of criticism of ICC, and this criticism says that the ICC is too focused on the African continent. It is common knowledge that the same response was given by the former ICC chair. As for your second question, yes, the Russian Federation president has issued a decree stipulating that Russia has no intention to be a signatory to the ICC statute. The situation is as follows. The ICC prosecutes for most grievous international crimes. According to Russian Federation law, Russia is still committed to its obligations and responsibilities. Thank you. I have a question. Some Western and Russian research papers claim that the ICC jurisdiction is universal. Do you think that we can indeed assess its jurisdiction as universal? Thank you very much for your question. Yes, you're right. Western scholars as well as Russian scholars have been discussing this issue. Well, we should say that indeed the ICC's jurisdiction covers crimes that belong to universal jurisdiction as well. While the statute was drafted, this issue was passionately discussed because members of some states did not favor the ICC having a universal jurisdiction. Therefore, the trade-off was to grant it a complementary jurisdiction. So therefore, this means that the ICC has a complementary jurisdiction. Yes, you can't be more right, because the principle of complementarity does not imply the principle of universality. Universal jurisdiction is implemented unilaterally within one state only. As for Tajikistan, in August 2002, Tajikistan has joined the treaty between Tajikistan and the US. This treaty was signed by a number of countries, and some of them are parties to the ICC statute. But this fact does not incur any challenges. Therefore, my question, provided that a number of states, such as Albania, Montenegro, Georgia, that have signed these treaties after they had become state parties to the statute. What are the implications behind this situation? Because those are obligations that have to be undertaken. On the other hand, signing this treaty implies failure to surrender US citizens to the ICC jurisdiction. And therefore, my question, what should be done about this situation? Because there is a conflict of obligations. How can we develop a bigger picture of this situation? Is there any opportunity to think outside the box? Thank you very much. This is an exciting question. Chapter 4 of my dissertation is devoted to issues of cooperation against the setback of this treaty between Tajikistan and the US. Apparently, the obligations undertaken by a state signatory to both treaties, to the statute and the treaty, has to look at which obligation has been undertaken prior. So as for Tajikistan, the treaty with the US was signed in August 2002. Therefore, our suggestion is that Tajikistan has to address the other party of the treaty to amend the provisions of the treaty so as to prevent potential controversies. Well, I hope that you're satisfied with my answer. Thank you. Any other questions? Yes, please. Has he got it? I switched on the mic. Well, my question is as follows. It is well known that Russian scholars and Soviet scholars used to refer to two groups of international crimes: the crime committed by a state and an international criminal crime. So what's your take on this system? Because it is directly related to the activities of the ICC. Yes, indeed, and I remember such authors as Mr. Troinin, who wrote a book published in 1970s on international crimes. Well, as for the ICC, its jurisdiction covers 4 groups of crimes. Those are crimes against humanity, military crimes, genocide, and aggression. All of them are international crimes. My first conclusion is that by prosecuting top-rank public officials, the International Criminal Court gives a negative evaluation of the state overall. Thank you. Some more questions? Do we have any more other questions? Members of the audience, do you have any questions? No questions? Thank you very much. Madam Khamidova, you can take your seat.
We have received reports from reviews from members of the Dissertation Council that were duly published on the St. Petersburg State University website. Allow me to announce the reviews, one of which was submitted by head of the Department of International Law of the Institute of Philosophy, Political Science and Law of the Academy of Science of the Republic of Tajikistan, Dr. Sayudamar Rojabov. My colleague deems the research topic as highly relevant. The defendant has produced a good attempt to provide a comprehensive analysis of the issues related to the accession of Tajikistan to the ICC statute. The review is positive on the whole. There is just one critical remark. Can I announce it? Despite the obvious merits of the dissertation being reviewed, I would like to clarify Ms. Khamidova's position and understanding of the following issue. The defendant talks of Article 3 of the Constitution, whose provisions are not duplicated at all in all the legislative norms of the Tajikistan Republic. In some part of the legislation of the Republic of Tajikistan, this provision is supplemented with a comment principles and norms of international laws, such as Article 6 of the Civil Code of the Republic of Tajikistan. Do you think that this amendment to particular specific legislation, do you think it exceeds the authorities of the public referendum that is conducted? On the whole, my colleague noted that the dissertation is consistent with all the necessary requirements and that its author deserves to be awarded the PhD degree aspired. The second review came from a candidate of science, docent of the Department of International Research all over Irina, who noted that the study is well-founded, stylistically and linguistically perfect. The issues studied in the dissertation testify to the practical and theoretical significance of the work. There are just two critical comments. First, the dissertation should have emphasized the fact that implementation is not an obligation according to the statute, unlike Chapter 9 of the Rome Statute. The ICC statute does not directly compel states to start national prosecution for crimes. It only creates a legal framework, a legal regime under which the state has to prosecute the culprits if they want to perform their jurisdiction. The states are interested in criminalizing international crimes, which reduces the necessity for ICC court interference. In Article 16 of the Constitution of the Republic of Tajikistan, we read the following: citizens of Tajikistan are protected by the state outside the boundaries of the country. No single citizen can be extradited to a foreign state. Extradition to foreign states is only allowed under a duly concluded bilateral agreement. The Constitution of the Republic of Tajikistan, the also mentions, lacks the norms that enable to extradite the citizen to a foreign state in case of international crimes being committed by them. So it is advisable to adopt the following amendment to the Constitution. The citizen of the Republic of Tajikistan may be extradited to international institutions participated in by the Republic of Tajikistan for holding this person accountable in accordance with the statutory documents of these institutions, unless the citizen can be made accountable within the national criminal justice system. The procedures for amending the Constitution is provided for in Article 9. Amendments, which says amendments and additions to the substitution are only legitimate if made under the popular referendum and will be approved by Majlis by at least 2/3 of the vote. Amendments to the Constitution of Tajikistan might require a referendum, in which case its results may vary. If the citizens vote against the amendment and the statute has already been ratified, it creates a difficult legal situation, a legal conundrum. How do you think it can be resolved? These remarks, of course, do not undermine the scientific value of the findings obtained as a result of the study. The author of the dissertation deserves the PhD degree sought. The third review came from Belarus, from the head of the Department of International Law of a private education institution, BIP Institute of Law in Minsk, Doctor of Law Olga Tolochko. She provided a positive feedback to the dissertation, commenting that on the whole the results of the dissertation are novel for legal science. They are reliable due to modern research methods being used by the author. There is only one critical comment. The author's suggestion to make an amendment to the Constitution of the Republic of Tajikistan regarding the extradition of citizens to international institutions in which the Republic of Tajikistan holds membership, including ICC. In the past few years, ICC has become highly politicized in its activities, with multiple breaches of human rights during extradition, which can be used as a source of pressure on the state. However, this small deficit does not invalidate, does not undermine the scientific validity of the findings. The author of the dissertation definitely deserves the scientific degree sought. Now, let us hear from the members of the Dissertation Council. As I am in office today, let me begin with myself.
So I analyzed the dissertation. I believed that the topic is highly relevant, exciting, valid, and generates a lot of questions. It is thought-provoking. The defendant was very careful about analyzing the data by assessing it and providing her own original opinion on all the issues. I should say personally that I love this paper. It is original. It is highly worthy for Russia, not as well as for Tajikistan, and so many other countries, including the CIS countries that have not become parties to the Rome Statute so far. and are still thinking. Well, and the conclusions on all the up and down sides of joining the statute are highly relevant for Russia. I'm not going to read my review just because I'm limited in time, for one thing, and it has been downloaded to the website long ago, so you could look at it, you could read it before. But I have two things to focus on. On page 2, the defendant defines universal jurisdiction against the setback of countering international crime. The definition is as follows. It is defined as prosecution of individuals or entities, irrespective of their citizenship or residence. Such crimes include piracy, trading in slaves, human trafficking, terrorism, hijacking of vehicles and aircrafts, as well as other types of crimes. Apparently, the defendant does not accurately discern between the international crime and an international treaty crime. International crimes indeed imply a universal jurisdiction, whereas crimes in accordance to international treaties are covered by the jurisdiction of the states that are parties to these treaties. My other commentary refers to pages 154-156, stipulating that the ICC statute provisions and the power to prosecute citizens that are citizens of state parties contradicts the Vienna Convention. We should not forget, however, that entities accused of international crimes are subject to universal jurisdiction. Such jurisdiction is the power of the ICC as well as all other states, including the state of the citizenship of the offender, provided that such a state is engaged into a surrender agreement or a legal assistance agreement, then the jurisdiction is unclear, and therefore the ICC does not have a universal or exclusive jurisdiction in this respect. These drawbacks refer to very technical issues, whereas the big picture is that this dissertation is in full compliance with all the requirements, and the defendant deserves the aspired degree in law. who's the next member of the Dissertation Board. Professor Valeev, the floor is yours.
Thank you very much, dear colleagues. I'm happy to greet you on behalf of the Department of International Law of Kazan Federal University. I am really grateful to you for the confidence and for the trust that you had in me when you were including me in the Dissertation Council. As for the dissertation by Ms. Manzura Khamidova, it is known that by the beginning of 2017, the Rome Statute was ratified by 24 nations, including the USA, China, and, as I mentioned before, the Russian president signed a statement that Russia will not be a member in ICC. Probably this is related to the events in Crimea, South Ossetia. In the past few years, ICC is often criticized by African states. 9 out of 10 investigations are related to African countries. So it's highly a coincidence that many countries chose to exit the statute. The costs of the activity of the ICC have been really high, up to $1 billion in expenditure. At present, the future of the ICC in the long-term perspective is not threatened. It still is used by many European nations. On the other hand, developing an effective strategy and avoiding disbalance is highly advisable. Under the circumstances, when the activities of the ICC receive controversial responses on the part of the world community, the dissertation of Manzura Khamidova is highly relevant and timely. Of course, the states that have joined the statute, that have ratified the statute, encounter many problems because they need to bring their legislation into harmony with the requirements of the statute, including the criminal code, the criminal proceedings code. As for Tajikistan, this is the only state in the CIS which has ratified the statute. The other countries with identical legal systems are interested in this phenomenon, so this makes the comment by Ludmila highly interesting. Manzura Khamidova stresses that the principle of complementarity of national legislation of Tajikistan is highly relevant. In this connection, Ms. Khamidova rightly criticizes Article 17 of the Constitution. I mentioned this in my review, so I won't go into too much detail here. Ms. Khamidova rightly emphasizes that many situations arising from the ratification of this document highlight a lot of bottlenecks in the legislation of Tajikistan. And I also mentioned this in my review. Ms. Khamidova suggests that the special legislation be passed about the collaboration between the Republic of Tajikistan and the International Criminal Code. I suggest that it's highly fair that many principles, many conclusions formulated by the authors adequately reflect the content of the dissertation. They are novel, they are highly relevant, and of course they can be applied and used in Tajikistan in legislative activity as well as in the learning teaching process if the defendant indeed specializes in it. I would like to focus on just several critical comments and questions. You said that the criminals must bear responsibility, must bear liability in adherence to Article 7 of the statute. However, there is a question. How do we deal with the jurisdiction of the ICC in case the state does not or will not conduct investigations of crimes? Let me emphasize this critical comment. There is another complex question that I cannot answer myself. How do you deal with the implementation in the new criminal code? If you consider that the statute specifies 5 forms of genocide, 15 forms of crimes against humanity, and a number of different military crimes, the Commission of International Law is currently working on the Convention of Crimes Against Humanity, because there is a legal framework document on genocide, but not on crimes against humanity. I didn't find anything on that matter in your dissertation. According to the International Center of Human Rights, named after George Washington, about 50% of the states, member states, do not have any laws about crimes against humanity. If you take any criminal code of any state, they're formulated very concisely, very briefly. How do you go about including crimes against humanity into the crime code? And another question is it possible quote to use the ICC statute? I worked at the committee of AGS where it was said that courts can apply international laws, international legislation. There is a decision by the Supreme Court plenum about the jurisdiction, about the acceptance of principles of international law. Maybe the crime code of the criminal legislation of Tajikistan will follow suit. My remarks are debatable, and of course they do not invalidate the high quality of the study, nor the provisions submitted for defense. I confirm that your study is consistent with the existing requirements, and that the author deserves the aspirant degree, PhD degree. Thank you very much.
Thank you very much. And now may I turn it over to our foreign guest. Do you hear us? I'll now turn it over to Professor Safarov. You're off. You have switched off, haven't you? Oh, probably we would recognize ourselves to some other member. No, Professor Safarov is with us. I'm sorry, I'm not the one to blame here. Now the floor is yours, and the time is 10 minutes. Distinguished Madam Chair, distinguished members of the Dissertation Board, distinguished members of the audience, may I first and foremost extend my gratitude to St. Petersburg State University for the opportunity to be among the members of the Dissertation Board. As for the dissertation, well, it is theoretically and practically a valid piece of research. What's the matter? Streaming is off. Now you are back with us, Professor Safarov. Well, there are some technical impediments. Well, I should say that implementation of the Rome Statute could be done in different ways. We can look at practices in Germany when the Constitution was redrafted and the rights were granted to the European government. A different practice is amendment of the Constitution when the domestic law is redrafted. In whatever case, without any preliminary work, we cannot launch international criminal practices because the Rome Statute would not allow to launch the activity of International Criminal Court in compliance with the complementarity principle only. Therefore, the overall assessment of this paper is high. There are some minor debatable issues. One of them is that the defendant should be more focused on the fact that the very concept of complementarity requires state parties to amend their national legislation, although this is not directly stipulated in the statute. All the critical aspects are debatable, and they do not invalidate the findings of the research overall. Thus, the defendant deserves the aspired degree in law. Professor Lyakov, the floor is yours now. Thank you very much, Madam Chair. I'm also grateful for the opportunity to be here. and to participate in the discussion, in promoting the endeavors of our talent pool. May I, on behalf of Madam Corbett and the International Legal Association, extend my gratitude and extend the welcoming address, as well as to the members of the audience and members of the Dissertation Board, as well as the Military Academy, where I used to work. The issues of international cooperation in institutional or legal context are our interest as of 1960s, together with Madam Chair, Mr. Rodionov, and a litany of other scholars in law. Well, one of those who you may have mentioned is my student. It's my former student. Yes, I know them all too well. So we are cordially grateful to you for all the skills that you have taught us. This issue is both novel, but however, it is eternal, because it has been always there, as we all know. Crimes are always there, and we cannot get rid of crime, because this is something which is vested into the web of our society. However, our expertise is the social and the political aspect of such deeds. And indeed, such deeds are highly dangerous. International deeds pertain to policy and to law, which makes it ever more complicated and compels our defendant to conform to this challenge. It is also a specific challenge for us as well. The dissertation is practical and relevant because it looks at the international criminal court practices as well as the civilization overall. For our civilization, international crimes have now achieved a larger scale, embracing terrorism, genocide, and other forms of aggression that have to be countered. And preventive measures are also highly relevant. This is our top priority. Countering and prevention, those two aspects should go hand in hand together. What Madam Khamidova has pointed to is that we should both follow along both of these tracks, so that to ensure that such judicial international bodies like International Tribunal, Criminal Tribunal, and the International Criminal Court to take top positions, to be leaders, both in terms of expertise and in terms of management and policies. Well, my review is on the website, and you can read it thoroughly. And I'm not going to read it out. My commentaries are actually the same. And, like my colleagues, I highlight that the dissertation is in conformity with the required criteria for a PhD. In my background, I have experience of being a member of 2 dissertation boards, so I know what I'm talking about. So I assert that the research complies with all the requirements, whereas Madam Khamidova deserves the aspired degree in law. So, what's my time? 3 minutes. Good. I'll take these 2 minutes to discuss the following thing. I believe that the structure of the dissertation is indeed original. It is exempt of any administrative bias. Well, you know what I'm talking about. And actually, it makes this text, this narrative, understandable to a broad audience of readers, so as to fuel the analysis. And probably tomorrow someone will refer to this dissertation in their research paper. May I take advantage of the remaining 90 seconds to overview some general theoretical issues. My question to the defendant covers the difference between international criminal crimes on the one hand and classical international crimes. Those are the crimes committed by a state, by a government. Well, in Russia, we sometimes undervalue general theoretical aspects related to law and criminal law. Theory says that the subject of a right, of a power, is the one who has been granted these powers. But here we forget about a different definition that implies that the subject of powers is also a party to law. And this is what we see today when entities violate to be parties. They refrain from being parties to law. And therefore, a legal entity is a party to legal interaction. The perpetrator, the violator, whether they want it or not, they will be prosecuted after all, whereas the parties to the legal interaction have to comply with due diligence, have to be fair in their actions and their deeds. As for the classification of crimes, well, this splits crimes into 4 groups: national crimes, with or without foreign entity. This is cross-border, transnational, multinational crimes, international criminal crimes. Those are deeds committed by individuals, and the international crime committed by a state. Once again, may I underscore that the defendant has successfully solved a set of exciting, controversial issues and deserves the aspired degree of a PhD in law. Thank you so much. I hope that your message to the legal community will be heard. And now, well, we have 2 more reviews. Nikolai, the floor is yours.
Thank you, dear colleagues. I will try to be brief. Especially given that the previous reviews focused on the relevance and the novelty of the study, as well as its key content components. So, if you allow me, I will save all the compliments and focus on a couple of critical comments that I have. They might seem insignificant, but at the same time, I think they might be of relevance. My first comment concerns paragraph 1, chapter 1, where the author says that despite the fact that ICC is entitled to start criminal proceedings against physical persons, one may conclude that the state accused in international crimes, the International Crime Code gives a negative legal evaluation of the state itself and state institutions in particular. This conclusion was made by Ms. Khamidova. However, there is one question or clarification point that needs discussing. What is the relevance of this conclusion if the author says that this evaluation does not lead to any legal consequences for the state in question, for the nation in question? What is the legal importance of this negative evaluation? My second comment is related to seemingly insignificant things, practically proofreading. The defendant suggests that the Constitution of the Republic of Tajikistan be amended. The Republic of Tajikistan, quote, can be extradited to an international institution where Tajikistan holds membership, for holding the citizen accountable if this citizen may not be held accountable within the framework of national legal justice. So how adequate do you think this wording is? Do you think that this amendment might be an indirect acknowledgement of the fact that the Republic of Tajikistan does not hold the fullness of power on its own territory and is unable to hold its own citizens accountable for criminal offences? Another comment partly overlaps with what our colleague from Azerbaijan has articulated today, We haven't heard a full, detailed response to this comment. At the same time, I deem it necessary to touch upon this question. Namely, this is the situation related to the existence of bilateral and multilateral treaties. However, the situation has been analyzed, so the only question I might ask is how to resolve this collision between the two international treaties. I heard the answer, I heard the response, so no problem here. My conclusion is that the dissertation is compliant to the necessary requirements, and the defendant definitely deserves the aspired PhD degree. Thank you for your contributions. You didn't break your time limit. You were even briefer than the allowed time. Valentin Lemonchik, please. I gave a positive review to the dissertation. The review is published on the website of St. Petersburg State University. At the same time, I would like to focus on a number of issues which, first of all, I found attractive about this dissertation. For example, I am quite supportive of one of the provisions, one of the premises of the dissertation that is submitted for defense, namely the idea that whenever the ICC accuses or convicts state dignitaries, it gives a negative evaluation of the actions of the nation, of the state itself. The evidence for this conclusion includes doctrinal studies and the analysis of legal practice, criminal practice. This conclusion is, of course, highly reliable and novel. Amongst the other premises submitted for defense, one idea that I find quite appealing is the problem of national judicial institutions being biased. This problem of bias is never considered by the ICC statute. The author gives some very sound suggestions as to how to incorporate the concept of bias into the reasoning of the ICC. As you know, the ICC and its activities, its operations, are related to both legal problems and political problems. In a dissertation, it's a very complicated thing not to veer in, not to steer into the field of political science. However, Ms. Khamidova does observe this balance between legal aspects and political aspects, and her chapters 2, 3, and 4 offer a really high-quality legal analysis of the problems related to the implementation of the ICC statute in the criminal legislation, in the criminal proceedings legislation. And this is one of the key merits of the study. At the same time, I wanted to point out that I did give one critical comment. As I understand now, it's related to the amendment of the Constitution. The ICC is just one judicial institution. So if the Tajikistan accesses another international institution, will you change the constitution every time you do so? Thank you, Valentina. I think maybe some members of the audience would like to take the floor and ask questions. After no more questions, Ms. Khamidova, can you please provide your responses, your feedback to the critical comments that were made by your reviewers? You have 15 minutes.
First and foremost, may I extend my gratitude to Madam Chair and all the members of the Dissertation Board, as well as other scholars who have submitted their reviews for my dissertation. If I may I start with responses to the commentaries of members of the board, followed by responses to external reviews. I will follow the order of the speakers in my responses. For the first commentary by Madam Galenskaya about the universal jurisdiction and its implementation to international crimes only. Well, I agree, this is indeed that way. However, those who are parties to the treaty criminalizing piracy, human trafficking, trade in children and women, and those are represented by the majority of states, and therefore I implemented such terminology. As for the second commentary, I should say that the statement by the US is indeed a subject of doubt. Parties, non-states which are non-parties to the statute, can also be influenced by the statute. If a citizen of a state non-party to the statute is accused of crimes under the jurisdiction of the ICC within the territory of a state which is a party to the ICC, then the court issues a decision that the state's non-parties fail to prosecute such an individual. What they proceed from is the willingness and the ability, provided that the state non-party to the statute have to prosecute such individuals themselves. My response to Professor Valeev. As for the first commentary, I should note that the object of research are legal, is the legal interaction between Tajikistan and the ICC. However, to us, this issue has a broader scope and includes such aspects as international and national jurisdiction, as well as tailoring domestic law to international law. The second commentary refers to the Constitution of Tajikistan. To us, Article 19 of the Constitution of Tajikistan implies, in this respect, not only a normative act, but also acts that have legal force, so as to include international treaties. Therefore, this provision of the ICC statute is reconciled with the relevant provision of the Constitution. As for the third commentary, when the state is unwilling or is unable to investigate in a duly way, to us, such citizens can be surrendered to the ICC in compliance with the obligations undertaken by Tajikistan. In the fourth commentary, the distinguished member of the board implies that the statute implementation is most successful when specific crimes and crimes against humanity are incorporated into the criminal code of Tajikistan, which are still missing. Mr. Safarov, the first commentary on duly compliance with the international obligation and the Vienna Convention as of 1969 overlap with the first commentary of Madam Galenskaya. Therefore, may I provide just a common answer. I proceed from the fact that Tajikistan's law must comply with its obligations undertaken under the International Criminal Court Statute. As for the implementation of national crimes and their prosecution within the framework of domestic law, well, this issue has been covered in Chapter 3 in the dissertation. Complementarity principle implies complementarity of a specific crime in national law. To this end, paragraph 3 and 2 of the Criminal Code of Tajikistan and paragraph 3.3 of the ICC statute. Mr. Lahov, your first commentary. CIS legal systems are different. Therefore, what type of implementation could be best for Tajikistan and which are best for other countries? My take is that despite all the differences, the legal systems have a lot in common. They have much more in common than they do apart. Therefore, I remained focused not on technical issues, but on how they comply overall. I believe that these issues are shared by all of us. Therefore, it will be practical to have some specific strategy. As for the second commentary, I should say that the first conclusion of my research provides a general evaluation of legal implications. Some specific issues are referred to Chapter 2 and Chapter 3. As for the third commentary by Professor Lahov on Tajikistan's accession to the statute, I should note that on pages 58-59, I analyzed potential reasons, the rationale behind Tajikistan's accession to the statute. Smaller countries are more willing to implement, to undertake the obligations under the statutes, thus becoming state parties to the statute. Therefore, once being a state party to the statute, the country is first and foremost looking forward for some legal assistance. on behalf of the International Criminal Body and the international community overall. I believe that the Republic is geopolitically challenged. On the one hand, there is Afghanistan, with its combat actions over the last 40 years, and China, on the other hand, that has some territorial claims to Tajikistan. Those are the key reasons that are behind, the key implications behind the Tajikistan's signing the statute. As for the fourth commentary, referring to the permanent international judicial chamber, existed prior to the international jurisdiction, but here we are speaking about the international jurisdiction towards individuals. The fifth commentary has the same phrasing as the ones provided by Madam Talimonchik. Therefore, I will answer this commentary in my responses to Madam Talimonchik. My responses to Mr. Stoico. The first commentary. I should note that such assessment does not imply any legal consequences. However, this indeed undermines the legal status of the legal image, the international image of such a state. And this fact can be referred to by a different international criminal body as a counter-argument. This is also extra proof of the criminal actions and criminal violations of the state. The second commentary refers to the amendments to the Constitution. Well, we believe that such amendments would indirectly imply that Tajikistan does not have the full power over its territory, because such surrender of citizens to the ICC is indeed an irregular action. Therefore, Tajikistan has top priority in prosecuting its citizens for international criminal crimes. As for the third commentary, I should say that provided the US government rejects amendment to the treaty, then Tajikistan will have to face a choice between the two obligations. Either it undertakes the obligations under the statute or its obligations under the US-Tajikistan Treaty as of 2002. We believe that the ICC statute has a priority in this respect. My responses to Madam Talimonchik. Her first commentary is identical to a relevant commentary provided by Mr. Lyakov. So may I provide my joint answer? I believe that here what we are speaking about is how complicated it is to implement these practices. Such practices refer to such grave crimes as genocide, crimes against humanity, aggression, and military crimes. External reviews. Mr. Rajabov first question refers to Part 3, Article 10 of the Constitution of Tajikistan law. Here I should note that Tajikistan has its constitutional status only in terms of the priority of international legal tools accepted by Tajikistan. Here we have to adopt a specific approach. I cannot but agree with the opinion of Madam Tolachko, saying that a violation of human rights is a form of pressure, to exercise pressure on the state party. Surrendering a citizen to the ICC is indeed a violation of human rights. Criticism by Madam Orlova is identical with the questions asked by other members of the dissertation board, so I have exhausted all the critical aspects. Well, anyone willing to take the floor? Okay, no one wants to take the floor.
And I would like to give the floor to the research supervisor of our defendant. Dear colleagues, I will be brief. I would like to join the opinion articulated by members of the Dissertation Council. The defendant has completed all the goals. She provided an in-depth study of the subject, and that she definitely merits the aspired PhD degree. Thank you for your attention. According to our regulations, we must declare a small interval so that members of the Dissertation Council may discuss any questions they have. I would like to switch off the online broadcasting.
Я, правда, не очень знаю, что мы должны обсуждать, потому что отрицательных отзывов не было. Да? Все высказались «за». Да? Может быть, какие-то замечания есть, потому что дальше у нас должно быть поименное голосование. То есть я у каждого буду спрашивать, за присуждение или нет.
Да.
И каждый должен будет отвечать. После этого, значит, мы присуждаем ученую степень, да, и довольные расходимся. Не предусмотрено никакое заключение. Да. Тут просто сказано так. Нет, сказано так. Все написали, все высказались.
Ну, потом уточните, ладно.
А поскольку голосование...
The question of granting a PhD to the defendant is put to the open vote among the members of the Dissertation Council. I vote in favor. Thank you. Professor Safarov. Thank you very much. I vote in favor of granting the PhD to the defendant. Please. Likewise, I vote in favor of awarding the PhD to our defendant and wish further success in research. I vote in favor. Valentina? I vote in favor of awarding the PhD degree to Ms. Manzura Khamidova. I am the sixth member of the Council. I also vote in favor. Thus, the Dissertation Council unanimously awards the PhD degree to Ms. Khamidova in subject field 120010, International Law and European Law. Congratulations, Manzura. You have done a great job. I wish you further success, and I hope to hear from you from Tajikistan. You now have the floor, and you have 2 minutes. Of course, I would like to extend my gratitude to Dr. Marusin, my research supervisor, and all the members of the Department of International Law of St. Petersburg State University. Your advice, your assistance were invaluable and very important to me. But as our time is limited, I won't be able to give all the names of the members of this department, even though I would like to do so. Thank you very much. I wish you success. I would like to thank the attendees and interpreters, as well as our technical staff. And I would like to thank members of our Dissertation Council, those that are in attendance and those that are absent. Thank you very much. I love you all. Thank you. See you soon. See you sometime. All the best. Thank you very much, Ludmila. All the best. Come to St. Petersburg and answer to our requests. Thank you very much. Thank you.